Hello! Before you proceed to watch this video, I recommend you watch my short video, Quick Primer, Canadian Legal Precedents and What the R Means, to help you understand the premise of a legal precedent if you are at all unclear. Also, watch the other cases highlighted in this series to get the big picture of the injustices happening in our criminal courts. R versus WD, also known as the WD test. This was a case at the Supreme Court of Canada that challenged the way a trial judge explained the standard of proof to the jury in a sexual assault case, where there was no material evidence and, of course, it only hinged on credibility. It turns out that there are several of these cases at the Supreme Court level, as well as the lower appeal court level from province to province. Judges interpret the standard of proof differently, including Supreme Court of Canada judges, and juries are requesting clarification on exactly how to decipher this standard of proof, resulting in further discussion of interpretations that muddy the waters. Before this case, the standard of proof instruction read as follows. The trial judge is required to instruct the jury that they must acquit the accused in two situations. First, if they believe the accused. Second, if they do not believe the accused's evidence, but still have a reasonable doubt as to his guilt after considering the accused's evidence in the context of the evidence as a whole. In R versus WD, the main point of contention was whether or not the trial judge's reinterpretation of this original standard incorrectly implied that the jury only has to decide between two conflicting stories. The Supreme Court stated that there is more to the standard than just deciding who you believe. The court said that the jury would understand that based on the original instruction. However, the court went on to adjust the original instruction to read as follows. First, if you believe the evidence of the accused, obviously you must acquit. Second, if you do not believe the testimony of the accused, but you are left in reasonable doubt, you must acquit. Third, even if you are not left in doubt by the evidence of the accused, you must ask yourself whether, on the basis of the evidence which you do accept, you are convinced beyond a reasonable doubt by that evidence of the guilt of the accused. In this judgment, Justice Sopinka says, the burden of proof is the most fundamental rule of the game. Yet, it seems to be the most confusing aspect of the game, like a moving goalpost for those applying it in the decision-making process. All the while, the court is leaving it up to the jury and the judges to just use their common sense. Now, I don't think that this case in and of itself is inherently dangerous to the innocent accused. I think that the root cause of this case, which comes up time and time again, is the danger. Having to question what exactly the standard of proof is that the Crown is burdened with. What exactly is the decision maker, a judge or a jury, supposed to consider when deciding to what degree doubt is measured? R versus WD doesn't go far enough to clarify that. So, let's fast forward to 1997 to a case called R versus Lifchus. The premise in this case is the same as R versus WD. Did the judge make an error in reinterpreting the reasonable doubt standard? Except that it was for a criminal fraud case involving theft over $1,000 by a stockbroker who lied to his employer. The judgment in this case uses a very robust discussion to decide whether or not the trial judge erred in telling the jury to evaluate the concept of reasonable doubt as if these were ordinary everyday words, and to use measurements of haunting doubt, substantial doubt, or serious doubt, which may have the effect of misleading the jury. What resulted from this judgment is an explanation of reasonable doubt that is much more clear and robust than in R versus WD. A summary of it reads as follows. The standard of proof beyond a reasonable doubt is inextricably intertwined with that principle fundamental to all criminal trials, the presumption of innocence. The burden of proof rests on the prosecution throughout the trial and never shifts to the accused. A reasonable doubt is not a doubt based upon sympathy or prejudice. Rather, it is based upon reason and common sense. It is logically connected to the evidence or absence of evidence. It does not involve proof to an absolute certainty, and it is not proof beyond any doubt, nor is it an imaginary or frivolous doubt. And more is required than proof that the accused is probably guilty. A jury which concludes only that the accused is probably guilty must acquit. What stands out to me is this line: more is required than proof that the accused is probably guilty. In my opinion, any case that rests solely on the credibility of the accuser and the accused only has room to find probability. He probably did it, he probably didn't do it. She's probably lying, she's probably not lying. Without any material evidence, you are left with nothing other than determining probability. I don't see how it can be any other way. The other line that stands out to me in this is, a reasonable doubt is not a doubt based upon sympathy or prejudice. This equates to moral certainty, which is stated in this case as not enough for conviction. So, according to the principles of R versus Lifchus, any she said, he said cases of alleged sexual assault can never meet the burden of proof. Or in other words, any she said, he said cases should never find themselves in a court of criminal law. If you look at the recent R versus Uriar ruling, or the Mandy Gray case, it was based entirely on sympathy for the complainant, prejudice against the accused, and a moral certainty that the defense used every feminist-dictated ideological rape myth. This all goes against the R versus Lifchus principles. In conclusion, we have on the left R versus WD, which is applied to sexual assault trials. On the right, we have R versus Lifchus applied to other criminal trials. Do you see what's happening here? R versus WD is outdated and does nothing to clarify what reasonable doubt is or how to measure it. Yet, it is specially applied to win a conviction against a man that can only be assumed with moral certainty that he is probably guilty. So, to those whining about needing a special court for sexual assault victims, don't you see? You already have it. You already have your very own standard of proof. And when R versus WD is applied in combination with Faryna versus Chorny, a civil case, as it was in the Uriar case, you are lowering the standard of proof and abusing the law by convicting a man based solely on probability, sympathy, and prejudice. It's no wonder juries are used less and less in sexual assault cases, because, God forbid, they might ask for an explanation of reasonable doubt, prompting a judge to decide on the fly which definition to give them, WD or Lifchus. Do I want a conviction? But when it's a judge-only judgment, they seem to get leeway by the intellectually dishonest appeal courts to choose whichever model they want. Meanwhile, other criminal trials have a much higher standard. But if we overturn R versus WD, which was applied in the R versus Uriar Mandy Gray case, then we are only left with R versus Lifchus as the model or test for the standard of proof. Can this help weed out the liars and professional victims? I think it can.